I'm Reagan Persaud. I am counsel, and I specialise in care proceedings. So I don't really do anything else other than public children work. So this lecture this afternoon, which is to be on basically taking allegations from children and preserving that evidence. Oh, someone said they can't see my email in the chat. Let me just quickly do that. Is one I can deliver because I've been doing this particular piece of work for some time now. And so the handout I've provided is actually quite helpful because I think it summarises all of the key points anyway. And what we'll do is we'll spend some time discussing this all so that you have a proper understanding of this issue. Now, I believe everyone on the line is from a local authority, whether that be a solicitor, a social worker, a team manager. Samira, I've just put my email address in the chat box. If people can email me, then I'll attach the handout for the people who missed it. But I shall talk you through it all anyway, and we can get it to you after if needs be. Okay, so what is it we need to look at? So today we're going to look at what really you should be looking out for in respect of when children give allegations, what circumstances they can make allegations in, because that will help you to know when you need to be prepared to deal with this, what the guidance says about how these types of situations are to be dealt with, what evidential issues can arise when you go to court if they aren't handled properly, and what would be the impact of not following that guidance in terms of the allegations made by the children. So the first point I've written is, in what circumstances are children likely to make allegations? Now, I think you all know from a child protection perspective that in essence it can happen anywhere and any time. It can happen to school teachers, to social workers, as I put there, during direct work with them by, say, family support workers, fit workers. Sometimes relatives tell you about things they've said. So, for instance, mom can say that the child made an allegation against dad, vice versa. We've dealt with that private law kind of scenario. And of course, sometimes we just get anonymous referrals, a neighbour who wants to remain anonymous as they've told me this. So it can come from a wealth of places. And sadly, you can't always manage where it comes from and what you get, say the anonymous ones. But my session is really to focus on what you and the professionals working with the children need to be alive to, because we all know that when you go to court, no one ever compliments, or they very rarely compliment the social worker or the local authority to say, oh, you've done this really well, but they're very quick to levy criticism. And so we need to make sure that you are covered as best as we can in terms of ensuring you follow the guidance and you stick to the guidance and you know what the guidance says. So I'm still looking out for your emails, guys. As soon as I get them, I'm going to just attach it and send it back. Sadly, I haven't had many yet. I've had one email from Bryony, so I shall send the handout. There you go. Okay, so why is it important then that we record these matters correctly? And what I mean by record is generally deal with allegations made by children. Well, because it is, as you all know, evidence that goes before the court. When children make allegations, then our note of them, what the child says, will end up, if we issue proceedings, being the base of threshold. And I think we all know that. Or it can sometimes be very relevant for welfare decisions. And if it's done improperly, what can happen is the court can say, well, I'm not so sure what that child said is true for this, this, and this reason, which sometimes involves a social worker messing with it, sadly. It can therefore affect the weight that is given to what the child says. It can and it can fundamentally mean the child doesn't always get believed, sadly, and we can end up not getting those findings that we want. So to avoid that scenario coming up, which I think we all know about quite well, there were investigations, public inquiries done, the Cleveland report and the Ogilvy report, which both dealt with, at the time, sexual abuse allegations that were made by children and looked at how they were managed and what in essence went wrong with those. And really and fundamentally, this is where your Bible of guidance comes from on this particular area, and how you as social workers, team managers, service managers, local authority solicitors need to be thinking and dealing with these matters. So I've written there, well, what can we learn from this? And this is what I want to go through with you. Social workers have an investigative role. That's what the inquiry found. These are points the inquiry found. They should not be pushing for a certain agenda, but only to gather all relevant evidence. Now, pausing there, I've had many a case where when children say things to social workers, of course, they think, oh my gosh, that's awful that you've been through that. But the point of the inquiry was, just because a child says something doesn't mean that it's true. And in fact, What you as social workers have to do as social care is think, this is very serious. I must treat this seriously. It needs to be investigated, but do not necessarily make the decision in your mind that what the child is saying is true. Be alive to the fact that your role is to investigate it, to take it seriously, but not to make a decision on it. And if I'm to ask now, who do you think actually makes the decision on whether or not what a child says is true? You can put it in the chat for me. If someone can put that in the chat, that would be very helpful. None of you are responding. Can you all hear me? Court. Thank you, Sarah. That's absolutely right. Now, that might seem really obvious that, in fact, the decision is made by the court. But I have had cases where, sadly, when I've acted for a father, I always remember this case. I acted for a father, and they did a negative parenting assessment on the basis that he'd abused this child by physically hitting this child. And then when we got to the door of court and I said, the team manager had to come and give evidence in the end. But funnily enough, she said, no, it was my decision that he would be negatively assessed on the basis that he'd done this. And I said, well, you've not put it in your threshold. You're not seeking to argue it in court. You're not seeking to litigate it. So how have you made the decision that he has done this? And she said to me, in evidence, she said, well, it's the balance of probabilities, isn't it? And I think he's done it. And she had made that decision herself, applying the balance of probabilities test. Now, to be very clear, you should never do that. The balance of probabilities, yes, it is the legal standard, but it is a standard to be applied by the court. Whenever allegations are made, you as social care to treat them seriously, but it is not your decision as to whether or not they are true. And I flag that because that has quite wide-reaching ramifications, that sentence, because, of course, for instance, I had a case where one brother accused the other brother of sexually abusing him, and the local authority stepped in and moved the older brother to live with grandparents and said, well, he can't live in that house anymore because the younger brother said he sexually abused him, moved him to live with grandparents. And a year later, was still working with the family on the child protection on the basis that what the younger brother had said was true, even though the older brother kept denying it. Now, there were many issues in that case, and one of the big issues was, how did you make the decision that what he was saying was true? Because you shouldn't have made that decision. And if you need that decision making, you should have gone to court. You should have issued proceedings on that matter and invited the court to determine whether there was truth in that. Secondly, as I'm sure some of you have realised, that is not a private family arrangement. If you have advised and tampered with and in any way suggested, even just suggested, that a child should live somewhere else, that is no longer a private family arrangement. That is the law. And they had, in essence, moved that child to live with grandparents, and they had to pay fostering allowance backdated to the year ago when they decided that the family should move that child to live with grandparents. And they also had to pay damages to that child on the basis that they had separated that older child from his family, declared him as a sex abuser with no findings from the court, with no order to do that, and they should not have been interfering in the family in that way. So I come back to the original point, which is you have an investigatory role, and if you need clarity, if you need a decision on something of that nature, then you really need to flag it to legal, because that is a decision that may lead to issuing proceedings, even if it is to say to the court, we don't know where the truth is, and we need you to determine that. And of course, I think if any of you have had cases in court, you might have done either-or assessments. And you do the either-or assessments because you don't know if there's truth in this, and it has to wait until the court decides before you can act really one way or the other. So that's the position in respect of the first point from the inquiries, which is you have an investigatorial role. There is a second point that arises from that, though, which is when you speak to children, you need to be careful about what you convey to them. Because I've had a case, for instance, I had a case a few years ago, and it is about 4 years now. But in essence, the child made allegations about the stepdad beating her. And I still think to this day it probably did happen, but we didn't get the finding. And we didn't get the finding because this particular social worker had felt so sorry for the child, which is understandable, that she crossed the line in terms of investigatorial role. And so her notes included things like her saying to the child, I'm really sorry that he's beaten you. If there's anything I can do to make sure that you don't get beaten again, to make sure that you're safe, I'll do it for you. Now, what we'd found when the psychologist did her report was that this particular child had attention-seeking behaviors. And the argument was made quite convincingly in court by this social worker very clearly expressing to her, A, that she agrees with her and she believes her, and B, that she will pander to that and be there to the child every time the child wants something on the basis that the child says, that's hit me. But this child had continued for a year of making these allegations to the social worker because she thought that's what the social worker wanted to hear. And the social worker was encouraging that by showing her and saying, I'm really sorry that he's done that. Not playing that neutral role and just finding out facts, but very much convincing the child that she believed the child. And so when it got to court, the judge's view was whether or not it happened is something I can't determine anymore because the evidence has been contaminated through the social worker's conduct. She's encouraged this child to say certain things. And the result of that is if you can't make a decision one way or the other, then the parent, it has to rule in favor of the parent, and findings were never made. So that is something to think about, is the impression you give the child as well. And that has to start with your mindset, which is, I'm taking it very seriously what's being said, but I am not convincing anyone and I am not convincing myself that I have made a decision one way or the other. It is for the court to do that. Then it says there, children should not be subjected to repeat interviews. Now, we all know that when children say things, sometimes we need to go in as far to say the Section 47 process to further check what's been said. And I think that has to be a very careful line because, of course, you must check what is said and make sure it's accurate. But when you do that, you can't go in with repeated interviews and saying things to the child to get something out of them, what we call a disclosure interview. That is entirely inappropriate. So, for instance, I had a family support worker once. We had a report from someone anonymous that the child had said, stepdad hit me. And the family support worker then went in and spoke to the child on the round and said, how do you get on with stepdad? And the child didn't say anything negative. And then she went, well, do you know the neighbor told me you said this, so did that happen? And of course that is entirely wrong because the child then thinks, oh, you don't like my first answer. Oh, you're referring to that and that's the answer you want, so I'll give you that answer. And then again, the evidence is contaminated and that argument can be made in court. That's family support work, and it was made in court. And that family support worker led the child into saying that. Children are young, they're impressionable, and we have to be alive to these things, that things like that look like disclosure interviews, and this shouldn't be happening. You go in and you try and find out if what the child has said is something they will say again, if actually it's not just something that's confusing. But you have to be careful in what you say to them, and you cannot lead them down a certain path in that way. The third point, well, we've covered the who makes the decision, the courts. The fourth point, the disclosure point. Now, I have sympathy for social care on this point because you go to the police with this stuff and they always say, don't they, Harry's made a disclosure. Harry and Meghan, that'll be my children for today that we're going to refer to all the way through, Harry and Meghan. Meghan's made a disclosure. And actually, that is wrong in law. Does anyone know, without reading the handout, why the word disclosure is wrong? You can pop it in the box for me. Someone has to say something in the box, otherwise it's going to be awkward. Assumes it happened. Yes, absolutely. Disclosure itself means that there is something to disclose. Something's happened to disclose. Now, the word disclosure is fine if you've had a court finding. Thank you, Joe. If you've had a court finding, then it is disclosure because it's a fact then. But before that, when they're just saying things and we haven't got a court finding or a conviction against them, it is an allegation. And you have to be careful that that language doesn't permeate in how you speak, because I know a lot of social workers say to me, oh yeah, I know it's allegation, and just pay lip service to that, or rather recognize that, but then don't put it into practice. And what ends up happening is when the social worker statements come through, the word disclosure filters into it. And they don't mean to do it, but it's because they're not adopting the language that's necessary in day-to-day speech. So even if the police says disclosure, You need to be saying allegation in your conversation with them. In your conversation as senior managers speaking to junior social workers, you need to be reminding them when they say disclosure, no, it's allegation. We have to get that word removed from the language, because if you don't, what happens is the social worker gets in the witness box and says disclosure because she's nervous and she's trying to get her points out. She says disclosure, some really difficult judge will instantly pull her up on it, and submissions will be made that, well, she's clearly decided already that the child's telling the truth because she's using the word disclosure. And that is the risk. Or the statements come in and they're littered with the word disclosure. The amount of times I have to review final evidence and I'll see the word disclosure, and it takes hours sometimes just changing that word to allegation. And I know they're not doing it on purpose, but they're not adopting the language in the department, which is then reflecting in what the court sees. So that's why I'm making a big deal out of this one. It's a very easy one to fix, but it is allegation. That in its own way shows the court that you're neutral, that you're investigating, that you haven't made a decision on it, and it avoids submissions being made by the parents' representatives that you've already made up your mind because you're calling it a disclosure. Okay, so the next point from these reports: senior managers need to ensure that they have efficient systems to allow monitoring. Fine. Staff engage in the practice need structured arrangements for supervision and personal support. Yeah, I'm sure you've got that, but I've written this all down there, so you've got these last few points as direct quotes from the report. You can get an idea of that. One thing I would suggest is, my handout has got a few typos, so I apologize for that, but I do think the handout's quite useful as a little 8-page summary of exactly what needs to be done in practice. So what I tend to do is, if I get a new case that comes in and I read it and I think, okay, this is going to be one of those cases where it's going to hang on what the child says, I normally instantly send out to the social worker, to the solicitor, whoever's instructed me, this handout, and say, please read this, get an idea of how you're meant to do this and deal with this. And I would advise any managers on this link, any social workers who want to flag it up the channel as opposed to down the channel, to do the same, to circulate my handout by all means. Tell them that council apologizes for the few typos, but that the guidance could be treated as something to adopt and read it if you do have a case that comes up of that nature. I've also had cases where I've said, you know, if you've got a child who you're putting in foster care, and because sometimes as social workers, it's one of those cases, this child's been dying to speak out, and the second they move to foster care, stuff starts coming out. How common is that? Make sure the foster care has a copy of this handout. Speak to them and say, this is what's going to happen. This is how you deal with it. So by all means, I think that is part of the making sure that there's a structure in place to manage things. I'm sure you have your own internal processes, but feel free to use my handout, is what I'm saying, as part of that. And it's written in the way that it's almost bite-sized chunks of information for professionals to read. So by all means, use it for that purpose. Okay, so let's look at what happens when we don't follow this guidance. And I think REE is a very good example of this, because you can see there that Scott Baker made the point, permeating the whole case was the underlying theme that the child must be believed. What a child said must be listened to and taken seriously, but the professionals must be very careful not to prejudge the issue. Now, I put that in because I wanted you to see that it wasn't just me saying it. This can quickly lead to judges taking a very harsh view of social care if this guidance isn't followed. And so what I wanted to do then is for us to discuss the impact of this guidance on social care. Don't record things as disclosures. Now, let me also address this briefly. Do you think social care records ever come up in court cases? And I'm not talking about what you put in statements and chronologies that get filed in court. I'm talking about your own records behind the scenes that you make when you do stat visits and SIN visits. Kelly's written yes. Yes. Remember, guys, from a legal perspective, any piece of paper that social care puts pen to paper to, it's disclosable, and there is an argument for it to be disclosed. Now, even if it doesn't go into court cases, it can inform public inquiries. Don't forget that people have these data subject access requests they can make now as well, where they can get all their information. And so be very conscious that, okay, I know it's an allegation, it's not a disclosure, but and then you don't really take it beyond that, but be very conscious that every time you write that word, it can come back to bite you in the ass. And that's the reality of it, is that if someone requests the social care records and it's littered with the word disclosure, there's your argument. Social work is biased. Think about that. Think about what you write on the system and make sure that it is I wanted to say politically correct, but I don't think that's right. It is in line with the guidance on how to deal with allegations made by children. I've written there, keep accurate records of what children say. Now, I know a lot of social workers do this already, and it's becoming more and more common in my practice because I do a lot of local authority work, but I see this. But what you really need to be doing is always, when you do this one-to-one work with children and they say certain things, is to make a note of it instantly, and it's verbatim. The note has to be verbatim or as close as possible to verbatim. That is asking a lot of a social worker who sat there with a 4-year-old trying to keep their attention and also making notes at the same time. I am not for a moment saying that that's not a difficult task, but we should always strive to achieve as verbatim as possible because, and I'm sure you'll all recognize this, what we think a child means is not always what they mean. The way they use certain words could mean something different. It may actually mean something much worse than we initially thought it meant. And so that's why it's really important to get the exact words of what the child says. Also, for instance, I have a case at the moment that's going to be a final hearing next week. And it's about physical chastisement. And the children said stuff in 2014. And we did some little work with the family and we closed the file. And here we are again. And the boy's been ABE interviewed and of course said, Dad's been beating me my entire life going back to 2014. So I sort of said, look, we can't just turn around and say he's been hit last year, which is when we issued the proceedings. It is a pattern of behaviour that, according to the child in ABE interview, has taken place for years. Where are the 2014 records? Now, if you ask me, how much of the records I have had, the answer is, despite numerous requests, very little. Very few notes were made of the discussions had with the child back then. And also, when the social workers are now going to get in the box to talk about what the child said to them back then, so I can establish this pattern of behaviour and abuse that this child has suffered, the social workers are going to go, I can't actually remember that conversation, which is understandable. It's from 2014. But actually, my point back will be, well, if you'd have kept accurate notes of exactly what that child said at the time, maybe it wouldn't matter so much that you can't remember because the judge could rely on your notes. You could say to the judge, I know for a fact my practice is I make notes as the children say things, or I make notes the second I finish that meeting with that child whilst it's fresh in my head, and that is what you've got in front of you. So even though I don't specifically remember it, I can trust that because of my practice, that is what was done. And then the note is reliable. Fast forward 2021, when I'm trying to litigate this in court, you've undermined that child's evidence by not keeping an accurate note at the time of the fact that the child was reporting it. Because the parents will say, oh, we just fell out last year, so he made this all up last year. Did he though? Or was he saying it in 2014? He was saying it in 2014, and I wish I had the notes to show that. So that is why I'll say, even though at the time it's hard to make these accurate notes, even though you might think, oh, that's a lot of pressure, these things have certain ramifications that knock on later. You don't always issue proceedings over these things. You work with the families sometimes, you put support in, they respond well under a CP plan, and you shut it down. But it may come up in future, and you as a client department, social care, need to be covering yourselves by making sure that these records are there, so that if we do have to litigate in 5-10 years time, it's there, it's all very clear. Okay, so that is that. Then I've written, be alive to the fact that children are not always telling the truth. Take it seriously, but don't necessarily treat it as a fact. And again, that needs to be reflected in your notes. That actually, you comfort a child, but you don't say things to make them think that you know for a fact that they're saying the right thing and they're telling the truth. Do not give the child the impression. Think about body language in that respect, and think about whether your involvement as an individual social worker, like that one I told you about on that case, who I think with the benefit of hindsight, she should have really come off that case. But at the same time, she didn't realize that she was doing that because she hadn't had proper training. And actually, once she'd embedded herself so much with the child believed that that's how she would get what she wants by making allegations to that social worker, then really you're influencing that child without even realizing it. So that's why body language, the impression you give, the language you use is very important. Notes are very important. And avoiding certain language like disclosure, going for allegation instead, is important. Okay, so before we move on, has anyone got any questions? Because I realise I've been talking for half an hour. Does that make sense? Or has anyone got anything they want to ask me? No one's got any questions. Okay, wonderful. So as you'll see, we're already on page 3 of my handout. So I've noticed that this session is now for 2 hours. It's not going to take 2 hours, don't worry. So hopefully if I beat through this, then I can take some questions and you guys will have a lovely little afternoon. Okay, so let's move more deeply then into the Cleveland report and what came out of that. Any interviewer, oh, someone's written most. What does that mean? Absolute sense. Oh, bless you. Thank you. An interviewer in this delicate field must, however, be experienced and skilled. All those who provided evidence to the inquiry agreed on the points below. So let's talk about the points that came out of these inquiries. We've talked about the word disclosure. We've talked about going in with the intention of getting a disclosure interview. Sometimes you go in to clarify things and you just don't get anything back from the child. That's the end of it. Don't push that, because forcing something out of the child is not good evidence. It won't carry weight, and actually you'll be criticized for doing it. It's not going to help you any better than walking away with nothing from the child. All interviews should be undertaken only with those with some training. Now, I want to pause and tell you a horror story with this one. I had a case in the High Court 3 years ago, and I had a local authority, and we'd had this child ABE interviewed, and she'd made some by the police, and she'd made some pretty bad allegations against the parents. But as can happen, as happens with children all the time, they continue to speak. And after the ABE interview, she then made some further allegations, but this time of a sexual nature. So before it was physical abuse, now she was talking about sexual abuse. And you, as social workers and professionals on the line, will entirely know that that is simply the nature of how children disclose. Look, I just did it myself. Allege things. They speak. Some of the time, they then elaborate further. When they go into foster care, they give more information. As time progresses, they can speak again. And that doesn't mean that what they're saying isn't true. It just means that for them, dealing with their emotional difficulties, that is how it comes out. The court is very, very alive to that. And I have never in my practice had a judge turn around and say, oh, because she didn't say it the first time, it can't have happened. The court's very alive to the fact that children can say things and continue to say things about their past and the trauma that they have suffered in piecemeal form. So anyway, after the child made the sexual abuse allegations, I said to social care, have you spoken to the police? Are they going to AB interview? And funnily enough, the police said no initially, after a lot of pressure from the court that they then did the further interview. But when they said no, I said to them, well, if the police won't interview, you might have to think about appointing an AB trained social worker, because you have to have special training to do ABE interviews, and have them do that room in a proper ABE suite. And the service manager came back to me and said, no, the social work, that's expensive. The social work on the ground is going to go into their house, sit them down in a room and ask them a bunch of questions and write down their answers. And that'll be the interview that we put before the court. What are views on that? Can I just check? Can someone comment in the chat, or 1 or 2 people comment and tell me why that was wrong? I've got nothing. Do none of you know why this is wrong? Oh, I suppose I should give you a second. Shouldn't be in-house. Yep, good point. No proper training, absolutely. Well, what does ABE stand for? Let's start there. What does ABE? Yeah, thank you. Needs to be ABE. ABE is achieving best evidence. That is what it is. The process is designed to make sure that when children make allegations, and serious allegations, that the evidence is captured in a format that is appropriate, and that will mean that the court can give that evidence due weight, the highest weight that it can give. The service manager turned around and said to me, ABE is a criminal process. It's not something that we use in family courts or should be using, and this is fine. That is entirely wrong. And I had to go back and say, not only is that wrong, but as an advocate, I cannot stand up in the High Court of England and say, this is what we plan to do, and we're not going to follow ABE guidance. ABE is entirely the right way of dealing with serious allegations made by children. And we should always, if it's something that we're going to want litigated in court, push the police to get an ABE interview done, push them to investigate what that child is saying, because we need that evidence. Now, here's my geeky side of me coming out, and I'll just tell you this very quickly, even though it has no relevance. An ABE interview is still hearsay evidence. It is an out-of-court statement that goes to the contents of its truth. But the reason that we can invite the court to treat it as primary evidence is because it is done in a setting that is video recorded, so the court can see the child's mannerisms, the tone of voice, and all the rest of it that they get from seeing a witness face to face. And that the court can make sure the questions asked were entirely appropriate and verbatim answers of the child is properly conveyed to the court because it's video recorded. All of that is missed when you just talk to a child in a room. And sometimes you have to do that, part of the Section 47 process, part of firstly dealing with the allegation when it comes out for the first time. But that should be followed up with an ABE interview. The second point I need to make is, if you're going to push the police for an ABE interview, you need to get them to do it ASAP. I've had cases where they've gone, we can't find an intermediary. 6 months passes, 9 months passes, and then the child's, what value is that? The child's been influenced for 9 months. The child's allegation was fresh in their heads 9 months ago, and now you're pushing them 9 months later to talk about this. The longer that process goes on, the less credibility that child's evidence has. And that's why a social care, if you really want to push for proving things in court, you need to get them to do it soon. But can you use information alleged by another child? S told me that she was abused by T. The child has not said anything about T did to them. How do you progress? Well, that's hearsay evidence at that point. And you're more than right and capable of putting that in a statement, talking about what was said to you at the time. But quite frankly, the weight that the court can give to that will be less. That doesn't mean that it doesn't get investigated as part of a 47 process to see if there's other evidence that supports that, but it will carry less weight. But it still carries weight. This is family court. We have hearsay evidence as admissible. It carries some weight. Hopefully, though, you'll get better quality evidence to back it up and it won't just stand on its own. Okay, so excuse me, how does the ABE process work and what can we learn from it then? So we know that here I said the need to approach each interview with an open mind. So we know that I've just discussed with you, making sure your role is investigatorial, not determinative. The style of the questioning should be open-ended. I think that horror story I told you about the family support worker who said the neighbor told me this, did this happen, is a very good example of that. Because the child, it says they encourage a child in free recall. Let the child tell you what's happening. It's their story. Do not go in with your leading question saying, you told me this, is this true? If the child doesn't want to talk about it, then, the child doesn't want to talk about it. But your job is not to put words in their mouth. There should be, where possible, only one or not more than 2 interviews. That's what I was saying to you about, don't leave it too long, and actually don't constantly, and the second point of that is don't constantly have someone going in asking this child questions, because again, you end up having that situation where the child thinks, oh, people keep coming asking me questions because they want me to tell you about this. And then children embellish because they think that's what you want to hear. That's the argument that will be made in court. So you need to make sure you speak to the child to find out what's happening, and then you pass on to the ABE process, really, to get and capture a very good evidence early on in the process. The interview should go at the pace of the child. Well, you all know that, don't you? Don't put words in their mouth. Let them speak freely, capture what they say. The setting of the interview must be suitable and sympathetic. Who's in the house? Is the stepdad in the house when you're asking the child questions about this? I think you all know, don't you? For instance, speaking at school would be better, wouldn't it, than speaking in the house of the abuser? The interview should, where am I at? It must be accepted at the end of the interview, the child may give no information, and that's just what you have to deal with. There must be careful recording of the interview. So again, we have the video recording, but say if you speak to the child as part of the Section 47 process, now you don't always get, obviously, you won't be able to get a video recording then, and that's why that's particularly when the notes are important, because you've made a contemporaneous note of what that child says to you. But also, something I think people miss is when the court comes to look at, can we trust what this child says? There are a few other factors that play into that if the video interview isn't there, the ABE interview. It's not just what the child says, but it's what questions were asked of the child. And again, in your note, you should be making a record of not only the verbatim answer of the child, but the verbatim question asked of the child. So the court can see, no, I did not lead the child into this. This is me asking a very open question, and this is the answer I get back. Very good examples of that can be, for instance, where I have had workers do the 3 houses and ask a question that's completely irrelevant, just about family life, and the child comes out and says, Dad hits me. And that carries a lot of weight because they didn't go down that path. They didn't lead that child. They've accurately recorded it at the time, including the question. And that is the quality of evidence that the court will be able to go, I believe that child on that, because there's nothing that could have influenced that coming out. You know, I know that when these things happen, we always think, oh my gosh, they've been abused. We need to make sure we help them to get this out. And we need to make sure that the court sees this and makes a finding. But you have to take a step back and think, no, children do lie. And there are situations where children say things because they've been influenced. And your role is simply to record and investigate and pass on for the court to make the decision on. So that is what I would say about that. Very careful recording of the interview. It must be recognised the use of facilitative techniques may create difficulties. Yeah, we've talked about that. The great importance of adequate training. It may be in appropriate circumstances to use special skills of a facilitated interview. That's the ABE process. So where can things go wrong? Well, things can go wrong when, say, school staff, foster care, social workers start interrogating the child on the back of something said, leading them, confusing them. I think that carries even more relevance when you've got, say, a child who's 3 or 4 in particular. Say if you've got a 15-year-old talking about being abused, I'm not saying you should lead them. You shouldn't. This guidance is there for all children. But, you know, 1 or 2 mistakes can be forgiven, especially with a 15-year-old who's told lots of people that they've been abused. And if you go in as the 8th person speaking to them and lead them a little bit, then it doesn't totally tamper their evidence. But if you've got a 3-year-old, you can very easily lead a 3-year-old down a path. You can very easily lead a 4-year-old down a path. And you need to be mindful of that. Whilst I'm here, I should say, when you keep your notes of discussions happening, there's something else you need to be recording, and it is in here, but I don't know where it is. Record the child's presentation at the time, because, you know, a child saying, oh, daddy beat me, and laughing is very different to a child saying, daddy beat me, curled up in a ball, going all red. And I've had a case like that recently where, in fact, the child was the kind of child who had lied about different things. But on that particular point about dad sexually abusing them, when she told the social worker about it, I think the bit that really stuck with the judge was the fact that she curled into a ball to tell that story, lowered her head, became really red, lowered her voice. And the social worker recorded all of that in the contemporaneous note. And it's that kind of careful social working that gets us over the line, that gets that proven in court. So be conscious of recording the questions you ask, verbatim answers, and the child's presentation at the time. Who is present in the house? Where are you doing this? What time of day are you doing this? That is all very important. And remember, allegations, not disclosure. Okay, so the problems then we can have is you've led or confused the child. I've written there children influencing each other. Now, I don't know if anyone's thought about this, but it's happened in a few of my cases, and I think sometimes people miss it. When you've got, say, I've got a case, for instance, with 8 children, and the 2 younger ones who are 4 and 5 have started making allegations of physical abuse. Have they actually been physically abused, or is the fact that they're placed with the other ones who are 16, 14, 12, who were actually abused, and speaking about this in the house openly around their siblings, meant that these younger children are saying these things now? And that is something that I want you to think about, is that children can influence each other. And, excuse me, when you place children together, and if you've had 1 make an allegation or 2 make an allegation, you need to flag to the foster carer and to the social worker working on the ground and to the school professionals working. Be careful of what they're saying around each other. And if that kind of thing comes up where the older child starts talking about abuse, make sure that that is shut down appropriately in that moment. It can be discussed later. It can be discussed when they're one-on-one with the adult, but it is not discussed in front of the younger child. And actually a child appropriate conversation happens where with the older child to say, you know, I understand that you want to say these things, and these things are important for you to say, but please be mindful not to say that in front of your younger brother, you know, because when the younger brother starts saying things, the weight that can be attached to what the younger brother is saying is reduced. If we have a history of them just listening to their older sibling talk about this all the time. And actually, if they have actually been abused, that might get lost in that process, because the court will think, well, I can't trust that, you know, it's not just something they've been influenced with. So putting in that guidance earlier on is really useful, because if then that younger child says something, you can turn around and say, no, I know for a fact that we've never seen the older child talking about it. So we had a discussion with them to say, don't do it. You know the child, the appropriate way to convey that to an older child. I don't, I'm counsel. But have a think of that. When you place children, multiple children together, and the older ones making allegations, be conscious of that and have that discussion with the foster care of how to shut down those conversations, how to make sure you convey that in a child appropriate way to the child making the allegations. You make sure you do your best to avoid the evidence being contaminated. It might happen anyway. The other child might think, no, I'm not listening to you, I'll talk what I want. But then you've done your best, haven't you? And you have tried your best to keep it as accurate and clean, keep the evidence as clean as you possibly can. Record keeping not contemporaneous or not kept at all. That's another thing that can go wrong. And we've talked about the importance of doing that. Does the record include the question asked? And does the record include the child's presentation? We've talked about all of that. So we're getting through it. The opening report similarly criticises social worker departments fail to keep an open mind, which I will leave you to read, but these are little quotes from the report that you have to be mindful of, and the impact of believing it and taking it at face value, what the child says, which means that actually you end up weakening the child's account because there's that criticism that you've influenced them. And what does the case law then say on the back of this guidance? So is Orkney and Cleveland, or are Orkney and Cleveland, just some guidance that the court ignores? Well, no, it's not at all. And what the case law has shown us is that when these cases come up where things hang on what the child says to a very large degree, which it does for physical chastisement, it does for sexual abuse, people will start to quote the guidance to make sure that the rules are followed properly in court. People will start to go back to the ABE process and talk about whether the guidance was properly applied there. And that's why in those cases, you need to be very aware that you can be criticised as social care if that is something you didn't put into practice. Look at this part here. I mean, we've got this case here, haven't we, of Rochdale Borough Council. And there was a lot of criticism of Rochdale, which, you know, is relevant that for this particular case. And I don't know if you know, but local authorities don't always get named in cases that are published. So I'm sure you've seen that it's a local authority versus B or A. When does a local authority get named? It gets named and shamed. That's what it does. It's when the court decides there is a reason that the public needs to know that you have acted so inappropriately that it has to be published, that you have to be named and shamed. I mean, it's a bit cruel because, to be fair, all social workers make mistakes. All professionals make mistakes. They're working under a lot of pressure. But that is the consequences, that you could end up with a situation like that, where you're named as a client department for failing to do things properly. Sadly, this is one of those cases. Rochdale was named and shamed. And you will see that if you go on the next page, when the judge is considering the evidence, the breaches were not minor or trivial or infrequent, but substantial breaches, which rendered the information received from the children valueless and unreliable. Now, that is the consequence, is that if we don't do this right, and the court goes, I can't trust that that's what that child said because that social worker didn't make a proper note. I can't trust that that social worker didn't influence that child. I can't trust that the social worker hasn't gone in 10 times and spoken to the child to the point where the child's just saying it because the social worker keeps asking. The child might be telling the truth, but I can't trust it. And for that reason, I cannot make the finding. And that's your risk, is that the court will decide, I can't determine that that's actually happened. Not because the child might be lying, but because social care have tampered with the evidence by not following these rules properly. No one wants to be in that position. Certainly no one wants to be named and shamed. So I think that's why it's useful if we can pass this handout and these discussions back, just to run it up the channel so everyone knows. And be conscious that it's not just social workers, as I said, it's your family support workers, it's your fit workers, it's your school professionals, it is your foster carers. They all need to know that this is what needs to be happening on the ground, and each of them has a responsibility to approach this in exactly the same way. Notes, discussions, open-ended questions, not leading them down the path, being alive to contamination risks. So I shall leave you all to think about that, because I do think that this judgment is helpful to see the consequences if you don't get it right. Okay, working together to safeguard children, a guide to interagency working together. So I wanted to put this together because I do think that there is guidance from other sources, not just the reports, that are relevant for you to know about and to see how it can come back to bite you in cases. So in this case, obviously we've got relevant multi-agency statutory guidance applicable to social worker, foster carers and police. Sadly, the police don't always follow this very well, but that's their business and their problems. We're not them, and we're not going to do that. Local authority social care should see the child as soon as possible. That's the 47 process. And I don't doubt for a moment that that is something that social workers do. When an allegation's made, they investigate. You're very good at that. It's the police that tends to draw the ABE out. Initial discussions should be conducted in a way that minimises distress and maximises the likelihood that they will provide accurate and complete information, which we've discussed, avoiding leading questions, suggestive questions, where they are, etc. Record the assessment findings, so keep your contemporaneous notes of what's said. And then, of course, you have to inform in writing everyone, so that the parents even have to be told, look, if we're not taking protective steps, you need to know that this is what the child has said. To be honest, when serious allegations come out, you probably are going to take protective steps, but of course, you know that you have to inform parents of why. And then what it does there, this guidance, it also deals with Section 47 inquiries. Lead the assessment in accordance with the guidance. Well, we've already discussed that. Carry out inquiries in a way that minimises distress. See the child to ascertain wishes and feelings and circumstances. Interview the parents or caregivers. Well, of course we know that because that's part of the investigative process, isn't it? To try and find out what's gone on. Systematically gather the information and analyse the findings. Now, I want to pause with systematically gather information. I'm sure you all know that there is never a case where all we've got is what the child says. That might be how the police presents their case because they have different rules of evidence. But we don't work in the police realm. We work in the family realm. And in the family court, hearsay evidence is evidence. So when these children make these allegations, of course, you will speak to them. You will get to the bottom of exactly if there's any confusion there. You might set up AB interviews. But you should still try and gather a family history, a background, understand what's been going on in their lives. And I mention that because you'll all think, Reagan, we do that. We definitely do that. And I know you do. But what about, say, your non-accidental injuries from a family who has never had social care involvement before? Well, I think in those cases, things like child and family assessments, single assessments, finding out more about the family can actually be quite helpful. Because it helps me as the advocate who will then go to court to argue for you, to frame an argument, to see patterns, to see that actually there's something there that means that what this child has said is right, that actually you wouldn't have gotten if you didn't investigate those things. So we'll always try and gather family histories in those cases as well. I think sometimes we have to be careful that we're not complacent with that. And I'm not for a moment saying that you are. But for instance, I've had a case recently where we had a non-accidental injury. And the social care department decided, oh, we're going to place with the wider family. I think it was the aunt and the uncle. And then when it got to the door of court, I just said, I suppose I don't know why I mentioned it, but, you know, you're just dotting all I's and crossing all T's. And I turned around and said, have you actually done a background check on them? Expecting the answer to be yes. And of course, the answer was, oh, no, we've not sent off police checks. Why haven't you done that? Oh, they've got no involvement with us. They've never had involvement. The schools say the children for them. I'm like, okay, fine, but maybe you should. And when they sent off for it, they actually had some domestic abuse there, which meant that the Regulation 24 approval didn't go through. And of course, we had to turn to foster care. And the court turned to foster care. The court wouldn't underpin it with 38 6 months. The court knew that. But I just say that because I'm conscious that in these squeaky clean families, which is what I call them, that's my expression for them, these squeaky clean families that get known to social care because of one allegation or one accident, we still need to be undertaking the same processes and make sure that we don't get complacent because people look squeaky clean. Okay, so analyse the findings and evidence. So you'll have your big pool of evidence if you do it exactly as we discussed. Follow the AB guidance where a decision has been made to undertake an interview. Yeah. But here I've written as well, fostering standards, because you will know, as we discussed earlier, when children go into foster care, they start to make a lot of allegations a lot of the time. And actually, is it your responsibility, even with, say, agency foster carers, to make sure that they're trained to the right standard? Well, actually, if it's your foster carers, you should. Agency, I suppose they should do it, but it's still your children. It's still your evidence. And it can still come back to bite you when you present it to the court and try and get a decision on these matters. Because the evidence hasn't been gathered in a proper way. So what the International Minimum Standards does say is that they need to be trained in an appropriate, safer carer practice, including having skills to care for children who have been abused. And the way the court has interpreted that is they should know about ABE guidance. They should know about dealing with allegations from children. And that comes back to what I said, which is give this handout out, have discussions with them. Make sure that if you're placing children that you think they're going to start to speak out, make sure those foster carers are alive to that and they know how to deal with that. It's tiring going to court where the children have said things to foster carers and I write back saying, okay, we need a statement from the foster care. I need to know the date, the time of what's said, what questions were asked, what were the circumstances, what the verbatim answers were. So foster carer can't remember. She just says it was the other day, can't remember. What question was asked, can't remember. Has she kept notes? Because they should be keeping notes, foster carer logs. No. And this is what I mean is, don't for a moment assume that even good foster carers keep notes. Don't for a moment assume that they do. Remind them when you're placing these children, say, this is a child that might speak out. Here's your guidance. This is what I expect from you. Remind them of it because that is the evidence that will come back to be quite handy. Okay, achieving best evidence then. We've talked about ABE, so I'm going to very briefly cover this section. But in essence, if you don't do it properly for ABE interviews, then that could come back to bite you. Now, I know that the police tend to lead ABE interviews, but I have actually had cases where, because the police have refused to interview, we've had to appoint ISWs, for instance, to do an ABE interview and borrow the police's ABE suite. I think if you're going to push for certain serious allegations to be determined by the court, you should try and get the police to do an ABE interview. I also, though, need to flag that if certain rules aren't followed in the ABE process, it doesn't automatically, none of the rules being followed means that the evidence can't be put before the court. It can always be put before the court. But as it says there, is that the question will be asked, which failures have the consequence of making the evidence inadmissible? Well, none, but it may reduce the value of the evidence to the point of almost vanishing point. So to having no value at all. And that is what you need to be alive to, is that ABE is something the police do, but something you might have to do if they refuse. But in any event, ABE and all of the guidance on it and the training is useful because it reiterates all of this. It tells you exactly how to do this on the ground. If you ask me to go out and do a section 47, even though I know all about this guidance, I suspect I'd drop one or two leading questions in there. And so ABE is quite useful because if people get the chance to learn about the process, to get some practical experience, that is useful to have under your belt. I also think if you know you're going to go out and do an interview, one of the things that you can take from the ABE guidance is they plan their questions and they plan their structure and they plan what they're going to go in and say. Have a plan of how you're going to go in with this, because that will help you avoid leading questions. That will actually help you, if you write your questions down first, to know what your questions were that you asked. And that's quite helpful as well. Okay, so that's ABE. And what can we learn from it? Listen to the children. Do not stop them speaking freely. Where it is necessary to ask questions, making sure they're open-ended. Ask no more questions than are necessary. Make a comprehensive note of the discussion. So we've got time, setting, people present, what was said, was anybody else pregnant, particularly the actual questions asked. Make a note of their demeanour, so how was the child presenting. Fully record any comments made. Be aware of the danger of subconsciously or consciously indicating approval so that you believe them, because that can influence children. And children and adult witnesses may believe that the questions are being repeated solely because their earlier responses were incorrect or inappropriate, and then they'll change the answer. So if you ask something 3-4 times with a 4-year-old, they might think, oh, I don't like my answer the first time. Is it this? Oh, you like that answer. I'm going to play with that. And that is the risk, because risks, if not done properly, you've colluded with the child without meaning to. You've coached a child into saying things. Where an ABE interview follows earlier on recorded questioning, the court must give active consideration to the tainting of the interview, and it could lead to the child's allegations not being proven. Remember, at the back of your mind, it is our case to prove. We need to put untainted, clean evidence before the court. We need to prove it. And if we can't prove it, then the allegation isn't found, and the consequence of that is we have to treat it as having never occurred, even though we might think, no, this is really serious and I think this child's telling the truth. If you don't apply these rules, if you don't take an investigatorial approach and make sure you don't lead them and do all these things and keep proper notes, if you don't do that, you might end up with the child's allegation not being proven, and you might have to treat that stepdad as having not hit that child in your assessment. And I don't think many social workers would sleep very well knowing that something a child said has been contaminated by them to lead to that. Sadly, it does happen. Sadly, you can get name and shame and judgments for not doing it right. So make sure we think about all of that when we go in. Scott Baker then in Re-A. So there he's reminded of some principles, and it's the same principles again, where a child has been interviewed more than once, second and other interviews have diminishing value. Well, we've discussed that. Don't ask them, don't keep going in and asking lots of times. Make sure that the AB interview is relatively quick and the child's only questioned maybe once or twice. There's not, if the child's being asked questions by 10 different professionals, what he says to the 10th professional doesn't carry as much weight. What really matters is what he said to the first one, what he said to the second one, what he said to AB interviewers. Children are all of very tender years. They can be impressionable. They can pick up on things. Great care must be taken in assessing the reliability of the adults who report. That is you, because you are the professionals, and the foster carers and the fit workers and the family support workers. They are the professionals working with the family. I have to look at the climate with the children made there. Oh, look at that, disclosures, allegations, and decide whether the children may have been influenced. I have to consider whether the children are reported as having said what the children like, whether what the children have reported as having said is likely to be a fact or fiction. I have to consider the consistency of each account. I have to consider whether each child's behaviour before and after is consistent with the truth, and I have to look for reliable, independent evidence. So that is your family assessments to get the background. It would have been much more sensible to record all our conversations if there was to be any possibility of having an unrecorded discussion. The absolute irreducible minimum was that a full note be taken of all questions as well as answers. Okay, so let's wrap up. What can we take from this? Keep an open mind, investigate fully. Child isn't always telling the truth. Make full notes of what was said, questions, demeanour of the child, where they are, time, day, anything else relevant. Let the child speak freely. It's their account. Do not ask leading questions, even if they're not repeating what you want them to say. Think about your demeanour. Could you be influencing them? Use the word allegation and not disclosure until proven, I've put, and then you can go to town. And remember, social care do not decide whether the allegation is true, but the role of the social worker is pivotal as part of the process. So that's it, is my little lecture stroke seminar on how we should deal with these issues. And we've gone through all 8 pages. Let's start here. Does anyone have any questions about that? I'm not seeing any questions. Have I done such a fantastic job that no one has got a question? Sorry, I missed the 5 minutes. How can I get a copy of the handout? I'll make sure you get a copy of the handout. No questions. Does that address what you wanted us to, which is dealing with allegations made by children and preserving best evidence? Or is there something else that you want to know about on this particular topic? I'm not seeing anything. Will the video of the training be available? It will, yes. And then, guys, if you have no questions for me, remember what I say. Use my handout. Keep my handout. Filter it through social care. Make sure that everyone thinks about it. Remember when people go, yeah, I won't use the word disclosure in my statement. Well, it's not just about that. It's about making sure you change the whole language so that when you get in the witness box, you don't use the wrong word. You don't put it on your social care records in the wrong word. Remember, language is important. Yeah? And best of luck. And if there's anything else you want me to give you a lecture on or to discuss, of course, just let Lee know and I'll make sure I organise it. So unless anyone's got questions, I shall love you all and leave you. I think that's it. Looking at the comments, you're all saying thank you, for which I'm grateful. I'm just checking if there's any questions. No, I don't think there is any questions. All right then, guys. You've got off early this afternoon. Get yourselves off then and get a rest.